All right. So we're going to start with the Maryland side. Understanding whom the agent represents. It explains what seller's agent is. Somebody obviously that has a written agreement with a seller to sell the property. A sub-agent is somebody that represents or helps a buyer facilitate a purchase, but doesn't have a written agreement, a written buyer agency agreement. So they become a sub-agent to the seller. The reason I always suggest people start with this on their buyer consultation is that it explains here, it says, if you are viewing a property and you have not signed a brokerage agreement, that agent represents the seller. So this is a message, I think, for the buyer and for you, the agent as well. If you are showing property without a written buyer agency agreement, you're a sub-agent and you represent the seller. I understand that, you know, more often than that, you got to show property and maybe you can't, get back to your office and execute a buyer agency agreement, but just understand that without that written agreement, you're sub-agent to the seller. Buyer's agent is somebody that has a buyer agency agreement, a written agreement with the buyer. Dual agent, the broker would be in dual position here. You, the agents, would be in what's called a designated agency in Virginia. So that's for Maryland. DC does have dual agency, but don't forget that Sampson would prefer that you not practice dual agency, and it is our policy that you not practice dual agency. For Maryland, it's a two-part form. They would consent to the possibility of dual agency by signing this first part. I'm sorry, this is not the dual agency form. This is we're still in the understanding whom the agent represents. So let's say a buyer walks into your property and they say, well, I really don't have an agent. Can you write the agreement for me? I want to go and represent it. So you have to disclose to that buyer that you represent, you and Simpson Property represent the seller. Or let's say you are working with a buyer that doesn't want to sign a buyer agency agreement. And you say, well, listen, then I have to be a sub-agent on this transaction. We, Simpson Properties and the agent are sub-agent to the seller, and they would sign there. Let's move on to the buyer agency agreement. And I'm going to go through this fairly quick because I want to go over the DC part as well. Buyer agency agreement for Maryland and Washington, DC. So this is the same form you would use for Montgomery County and DC. I know it says Maryland here, but, and you could use it, if you had a buyer that wanted to purchase anywhere in Maryland, you can use this form. But remember that, once you start writing an offer, if you're in Montgomery County, it's GCAAR. Outside of that, for the most part, you'll be using Maryland Association of Realtors. But this buyer agency agreement would suffice even if your client wasn't purchasing in Montgomery County. Purpose of this agreement establishes a brokerage relationship and a contractual obligation. This is very important. It is a contractual obligation by both sides, the buyer and the broker. Broker responsibilities. Agent and broker agree to use professional knowledge and skills to locate and present real property, which is available to purchase and suitable for the buyer's needs. Assist the buyers through the process of property acquisition. Number 3, represent the interests of the buyer. And this is why you want a written agreement, because you do, that buyer should want somebody that is looking out for their best interest. Buyer's responsibilities is to work exclusively with you and the brokerage. And then if they were to see any for sale signs, it should communicate to you so that you are reaching out to the other party about this property that they're interested in. You don't want this buyer reaching out directly and maybe giving out information that would get in the way of negotiations further down. This agreement is between Sampson Properties and the buyer, not Sampson Properties and the seller. Often here I see seller pays commission or it is left blank. And when I ask why this is left blank, I'll get told that it's the buyer, it's the seller's responsibility to pay commission. Fair, yes, normally we do collect that. But paragraph 4C explains how that works. Right here, you want to establish some type of an agreement with the seller, okay, with the buyer. I'm going to receive 2 to 3%, 3%, 2.5%, whatever it may be. And you got to put something on here. I don't like it, and we will send it back if this is left blank. So have an agreement on what commission is going to be, how much you're going to charge, and put in your 345 broker fee on here. If there's an advance, like a retainer fee that you charge as your regular practice, you would put that on here. 4B talks about a protection period. So this is properties that you've shown. Let's say I show a property today. We agreed to part ways with this buyer tomorrow. Well, how long after I've shown you the property or the agreement is terminated, will my commission be protected on properties that I've shown you? So this protection period is very important that you put on there, because the buyer may look at this and say, well, there's no protection period. I like that property. I'm just going to end this agreement and I'm going to go and deal directly with the seller. Just make sure you have something on here so everybody has an understanding that properties that you're showing, you're owed commission for, even 90 days after the agreement is terminated.
Soto, Ernesto?
Yes.
It does have a protection time, but unless you have gone to somebody else, have a buyer broker agreement, that is in there. I couldn't quite see. The Virginia one has that unless you have gone to.
Yes, it's in B.
Yeah.
In B? Okay.
Yeah, it says right there, unless buyer enters into a new valid buyer agency agreement, just like Virginia.
Yeah, I think that's everybody have a right to do it, but I think that's almost like a non-protection there. Some people say, oh, give me your commission half of or 2%, whatever, and they go somewhere else.
Yeah, but this will protect you. Let's say you show a property today, you have 90 days on here. They can't go to a new broker terminate and go to a new broker the next day and go back to that property. You're procuring costs.
Oh, okay. Same property you're talking about. Same exact property.
Right. This is not like a blanket, like they can't buy anything that was on the market.
Okay.
What I mean? Like this is for properties that you show.
Yeah, that makes sense. Yes.
Paragraph 4C, amount of commission. Now, you should be able to articulate this to your client, that commission paid by seller is generally indicated as follows: in bright MLS of any properties using that multiple listing service, or in an addendum to the purchase contract for new home construction or properties unlisted in bright MLS. If you're showing a for sale by owner, make sure you get that written agreement, that written commission agreed upon. And there are forms that we have that are available. All associations have them. If you're showing a for sale by owner, don't just walk in there without an understanding as to what the commission is going to be. At least don't go in there with your client, have your client fall in love with the house, and then, you don't know what commission you're going to get. Make sure you have something established. Payment of commission. Commission is due at settlement unless buyer, after sales contract acceptance, fails to perform or is otherwise in default of the sales contract, or executes a release to which the broker is not party of sales contract after all contingencies thereunder have been removed. This is very important for your client to understand. We're dealing with a case right now where the buyer just decided they didn't want to buy the property. the buyer and the seller, the buyer's like, okay, you can have my deposit. Well, what about us? What about the buyer agent? Well, you know, we've done everything. You know, we were there. We're 1 day from closing. All the contingencies out of the way. The agent does have the opportunity to, or you know, leverage to go after that buyer for commissions because you've done your work. You know, you're ready to close. And our agent is debating that right now, whether or not, and it is your decision as the agent whether or not you want to sue for commission.
How difficult to collect it?
Oh, you got to take them to court. This is at the very top. This is a contractual obligation.
Mm-hmm.
So you got to go to court. You got to sue that buyer. Now, is that something you want to go through? Is that something you would, you know, some people do, some people don't.
This is a buyer, the agreement in DC and Maryland in general?
Anywhere okay. Really. Like if it's a contractual obligation, it is a contract between the broker, you know, the agent and the client. So, you know, again, you know, I want you guys to get very comfortable with these forms. I want you to be able to articulate this to your client, go through it completely, you know, and, you know, practice makes perfect. Just, you know, keep practice with every client. Make sure you go through the form, make sure you go through it and you got it, you know, memorized. And you know how to paraphrase some of this stuff. You know, you don't want to instill fear on people, but you want to make sure that they understand that this is a contract between the broker and, you know, these are the consequences of breaching the contract. These are my obligations to you. These are your obligations to me. You should be able to articulate. This agreement commences when signed and expires on 11/59 on. You must have an end date to your agreement. It can't be left empty. I will not endorse a buyer agency agreement that doesn't have an end date on it. Unless extended in writing or unless term is terminated as provided herein. If a contract of sale is entered into by the buyer before expiration date, which provides for settlement to occur after such date, this agreement shall be automatically extended until settlement has occurred or until the contract of sale is released in writing by the parties. I get that question every now and then, you know, hey, the buyer agency agreement expired last week and 3 weeks ago we entered, you know, we're under contract. How do I extend it? The answer is, you know, you can extend it in writing. However, you know, if for the purpose of this transaction, if this goes to settlement, you're protected. You don't need an extension for your buyer agency agreement. But, you know, if it falls apart, then now you're out of contract with your client. So if you do want to extend the agreement, go for it. You never know if the transaction is going to close or not, or if you're not, you know, not feeling like it's going to happen. The buyer's maybe looking for something different now. You know, you might want to extend it. But for the purpose of, you know, if you've gone under contract and your buyer agency agreement expires when you're under contract, you don't need to extend it.
Same as Virginia also, right?
Yeah. It's pretty across the board. Termination. Washington, D.C. This agreement may be terminated prior to expiration date only by mutual written consent by both parties. I love that in D.C. There's no fill in the blank. There is no, you know, Maryland's a little bit different. Maryland, the broker's responsibility established this agreement may be terminated unilaterally by either party prior to the expiration date, by either party delivering a, how many days advance notice to the other. And then number two, even if the broker's relationship is terminated under the terms above, the contractual obligation shall remain in full force. In fact, that's referring to like your protection period. Like, even though this is terminated, like it doesn't extinguish your protection period for the properties that you've shown. Unless terminated by mutual written consent to all parties. In addition, terms of paragraph 4B, which is your protection period, shall survive if this agreement is terminated early.
I like the DC better.
Yeah, DC is mutual. Like there's no, you know, there's no guess that you don't have to, you know, you can explain to your client, hey, this boilerplate stuff. Now you do, you know, every now and then you come across an attorney that's gonna cross that out. I love when attorney buyers get a hold of these agreements. It's all scratched up, doctored and stuff like that, which I discourage. But if it's not too bad, we'll let it go.
See.
Disclaimer and limitations. Buyer acknowledges the broker is being retained solely as a real estate agent. Make sure when you're giving advice that you are not coming across making statements that could come back and haunt you further down. Like the condition of the property, well, I'm not an inspector. This is what I think, but you should consult an inspector. What about the taxes? Well, this is what it is. This is what the taxes are on the property. But the title company is going to prepare the settlement statement, and they're going to collect all the numbers and give them to you. But here's an estimate. Make sure you're not making statements that you can't, that are going to be difficult for you to take back if you need to down the road. General provisions, laws, and regulations. Buyer acknowledges that broker must comply with federal, state, local laws and regulations. Buyer understands that. Sorry about that. Buyer understands that as a realtor, broker must also adhere to the Code of Ethics promulgated by the National Association of Realtors. Federal law. Make sure you're, treating everybody fairly. Delivery or deliver means hand carried or sent by overnight delivery service, sent by wire or electronic medium, which produces a tangible record of the transmission, such as a fax, email, which includes an attachment with an actual copy of the executed instruments being transmitted, or U.S. postal mailing. So you can't send notice by just sending an email. You have to attach the notice to the email. In the event of overnight service, delivery will be deemed to have been made on the next business day following the sending, unless earlier receipt is acknowledged in writing. In the event of U.S. postal mailing, delivery will be deemed to have been made on the third business day following the mailing, unless earlier receipt is acknowledged in writing. If you're gonna send notice via mail, send it certified. Make sure you have, you can trace it and you can confirm that it got there when it was supposed to get there, and then your clock starts ticking. This agreement shall be deemed enforceable when it and all addenda and any modifications thereto have been signed, initial, were required by buyer and broker or supervising manager. Very important. When I have, we do get emails too often, I think, or buyer agency agreements that need our signature after the transaction is closed. And it is signed by the client. The listing agreement was signed by the client before going on the market, and then it was signed by the agent. But it is not ratified until the broker has signed, or a supervising manager. And then you have to deliver a copy to the other person. So make sure you understand, you signing the agreement, the client signing the agreement doesn't mean it's ratified. It needs the broker or the manager's signature on that agreement. And then a copy delivered back to the client.
Okay, Ernesto, if I have a Maryland, let's say just listing, and I have to send you to sign it.
Yes.
Okay, I thought so, but.
And that's buyer agency agreement or listing agreement. And it says buyer, broker, or supervising manager. We have Kara is able to sign on these agreements. I'm able to sign, and any of our branch office managers are able to sign. We're all looking for the same things. We want to make sure you're completing these things appropriately. And what I don't like seeing sometimes is, they'll send it to one of the managers. Manager will reject it, and then they'll send it to me or another manager to see if we miss it. If one of the managers telling you, hey, we need this part filled out, fill it out and send it back to the same manager. Don't send it to a different manager to see if they'll sign it. You know, we're trying to help you make sure, you know, you have all the required parts of the agreement completed in order to enforce it. You know, we're not trying to make your, you know, give you any more work than you need to have.
Yeah, we're trying to protect you guys.
Exactly.
Mhm.
Exactly.
Now I understand. Yet a couple of days ago, I was happened to talk to Frank Evans,
Yes.
and he said he's no longer manager over there.
Yeah, we have a new manager at the Bowie office.
Who is he or she?
Carl Harper, that's Carl, right?
Carl Harper, yeah.
Yeah.
Carl Harper.
Carl.
And DC is gonna, we're gonna have, I'm still waiting for a couple of documents, but we're gonna have Noble Davis is gonna be able to sign off on DC stuff, which we haven't had. It's been me because, you know, we don't have any other managers for DC.
Mm.
But very soon we're gonna have one that will be able to endorse these documents. The paragraph headings are not the full intent of the paragraphs. Definition, singular includes the plural, boilerplate stuff. I do want you guys to include consent for dual agency on all your forms. Again, if you're representing the buyer, consent for dual agency, the first part just says that they're allowed to enter our listings. Which they should. You know, we've got a lot of realtors now. You know, you're seeing more and more transactions between SAMs and agents now.
Mm-hmm.
And when that happens, the second part needs to be endorsed by both parties. It says in the event of dual agency, when either buyer or broker declines to consent in writing, dual agency, either party may terminate this agreement by written notice to the other party. If one of the parties wants to go unrepresented, that's fine. So let's move on to consent for dual agency. Possibility of dual agency arises when the buyer when the buyer is interested in a property listed by the real estate broker and seller's agent and buyer's agent are affiliated with the same real estate broker. So the first part, which is this consent for dual agency, this basically just says there's a possibility that dual agency could take place. Are you okay with that? And that's why we want you guys to have this signed by the parties. And then the second part is affirmation of prior consent to dual agency, signed by both sides right here. Important information for the purchase of real estate. We're using Montgomery County. Legal requirements, all contracts must be in writing. Agency relationships, the buyer if buyers chose to have an agent represent them, they must enter into a written buyer agency agreement. Fair housing, you gotta follow fair housing regulations and laws. Financing, mortgage rates, fees, and products vary considerably among financial institutions. Buyers have the right to select a lender and to negotiate the terms and conditions of their loan. So we definitely want our clients to be, qualified before we take them, into any property, before we invest any time on a search of this property. So you refer 1, 2, or 3 lenders that they can speak to, and just explain to them that it is their choice. Like even if you ratify a contract with a particular lender, it doesn't obligate the buyer to close with that lender. You know, there's still the opportunity for them if if we can bring them back to First Heritage, for example, talk to First Heritage, even though the contract is ratified. Wire fraud, buyer is advised not to transmit non-public personal information such as credit or debit card, bank account, or routing numbers by email or other unsecured electronic communications. Emails attempting to induce fraudulent wire transfers may appear to come from a trusted source. It's probably happened to all of us. I had a case where my client called me. We had this conversation, and she called me. She goes, "Well, you're asking me to wire money," and I'm like, "No, I'm not." And figure out that somebody had spoofed my email, the email, and it looked like it was coming from me, but it wasn't. So make sure you have that conversation with your client. Transfer and recreation fees in Washington, D.C., unless otherwise negotiated in the contract. The recreation tax is paid by the buyer and transfer tax paid by the seller. Buyer may be eligible for a reduced recreation tax as first-time home buyer. Further information can be found at this website. With the exception of first-time Maryland owner-occupant home buyer, Maryland law requires that unless otherwise negotiated in the sales contract, the cost of any recreation tax state or state and county transfer tax shall be shared equally between buyer and seller. So this is what's customary. And I had a transaction that closed recently where I had sent the sellers, the net sheet, they looked at it, signed off on it, 50-50. Well, when they went to settlement, they asked the settlement attorney and say, hey, how come I'm paying this much in taxes? And it's a substantial amount. And they go, well, in the contract, you have 50-50. And they're like, well, is this something we could have negotiated? And even though I had explained to the client wasn't 100% happy with the fact that they had to pay this, 50-50 taxes. They had signed off on it. So the lesson to me was, hey, even though it seems like, and you got a lot going on in a transaction, make sure you explain to your clients that, it's customary, and this is, the way it's done most of the time, but it is negotiable. Property taxes, tax bill increase. Your property tax bill could increase substantially following settlement. For owner-occupied properties, Maryland and Washington, D.C., they have programs which are the homestead exemption, limits the amount of taxes on real property that may increase from 1 year to the next. So if you're on 30 years fixed, your monthly payment goes up, your taxes went up. Right of appeal, you do have the opportunity to appeal with the county. Disclosure of future property taxes. Montgomery County law requires that a seller disclose the estimated amount of tax bill for the first fiscal year following settlement. While Washington does not have such a requirement, the following year's assessment is available from the District of Columbia Office Tax and Succession Office of Tax and Revenue prior to the issuance of the tax bill. Vacant property, very important for DC. If you're doing business in DC, buyers are advised that the District of Columbia properties classified as vacant or blighted by the District Department of Consumer and Regulatory Affairs, DCRA, are subject to a registration fee and are substantially higher tax rate unless they qualify for statutory exemption. Owner of properties that are actively seeking to rent or sell their property may qualify for exemption. Further information can be found here. If you're listing a property from a builder or from, if somebody just renovated a property, one of those investors, and is flipping it, ask them about this, because it could be that it is still labeled as a vacant property. And there's the sales taxes that are going to be due upon the sale. So when you're listing a property, you want to find that out. When you're showing properties, this property look great. We do have clients that want properties that have been recently renovated, looks vacant. Ask the question, and you can check on the website, dc.gov, whether or not that property has that vacant or blighted classification on the website. If it does, there's going to be a lot more taxes due at settlement on both sides. This will affect the buyer's, closing costs too. So just make sure you're doing your research on these properties before you write the offer. Don't let that be a surprise at settlement. In Maryland, sellers are required to disclose known latent defects even if the property is sold in as-is condition. Sellers, with limited exception, are required to complete and furnish to the buyer the Maryland Property Disclosure and Disclaimer Statement. In Washington, D.C., sellers, with limited exception, are required to complete and furnish to the buyer the seller's disclosure statement. In D.C., it's just the disclosure statement. In Maryland, it's a disclosure or disclaimer. You can disclose or disclaim. And, you know, for Maryland, you know, make sure your client is filling this out as well as for DC. But don't tell them which, you know, explain to them what one, or read the form for them. But don't tell them which one they should whether disclaim or disclose. It is up to them. You know, you don't want to have a saying in that. It's their decision. Again, in DC, it's a disclaimer statement. That's it.
Can you go through a little bit more detail about if you do disclose what is involved and disclaim what is not involved?
I can share the forms on the chat box later for both. Yeah, there's you basically fill out a form. Yeah. Virginia is disclaimer. Mm-hmm. So you have Maryland, which is disclose or disclaim. You have DC, that's disclose, and then you have Virginia, that's disclaim.
Just make sure if they fill out the disclosure that it's complete, because there's a lot of questions, and the buyers are supposed to receive the completed disclosure. So you don't want halfway completed disclosure to leave the window open later for if a buyer wants to walk. So just make sure if they fill that out, it's the seller filling it out and that it's complete.
Right. Okay. Let's see, government regulation disclosure. The state of Maryland, Montgomery County requires sellers to make many disclosures regarding taxes on the property and on laws and regulations that may restrict or affect the used buyers of property located in Montgomery County should receive a completed and signed regulations, easements, and assessments, which is the REA, prior to entering into a contract. Inspections, make sure that buyer understands that, you know, even if there's a disclosure provided, that they still should get the property inspected to make sure, you know, they're aware of the condition the property is in. Number of companies provide home warranty programs with various types of coverage and deductibles. Consult your agent for further information. We have 210 and Super that are our partners. Make sure, I know with 210 and I think with Super as well. I know with 210 I have my own account where I go and, you know, and enter my clients' property and their information for a warranty if, you know, if you want included. Property insurance rates and availability are determined in part by the number and nature of claims and inquiries made on property's policy, as well as the number and nature of claims made by the prospective buyer. Homeowners Association condominiums disclosure. So you are to be disclosed your own disclosure of an HOA or a condo or a co-op via a resale package.
So how new it had to be? What is the time frame of that documentation? You
know, for DC, there is nothing that states the you know, how recent the documents have to be. I would say, you know, make sure there's no more than a year old. However, you know, if you're selling a property, you know, you should provide fresh documents that have the most recent bylaws, because you can also request an update as the buyer, which will extend that you know, the 5 days if they don't have a complete you know, or an outdated package.
So I think when you're listing, you want to have almost like a time frame of a listing time frame. That would be best, wouldn't it be?
Yeah, you do want to order them. I think when you, especially in this market, that, you know, everything in DC and Montgomery County is moving so quick.
Right.
when you list the property, you should have your order in. So that package is available upon ratification, so you don't have a lingering contingency out there.
Right.
Tenant rights: properties located in Washington, D.C. and within the city of Tacoma, Maryland, that are tenant occupied or otherwise defined as residential rental property will be subject to certain restrictions, regulations, and requirements as part of the resale. It is imperative that the buyer be familiar with the complexities of purchasing tenant-occupied property prior to entering into a contract. You have topo rights in DC, and I think in all jurisdictions, I want to say Maryland, DC, and Virginia, if there is a lease on the property, that seller should disclose that lease, because you're going to have to honor that lease as a new owner of the property. So make sure if you're listing property, if there's a year left on the lease, that you're disclosing that, or if there's 2 to 3 months left, that you're disclosing that to the purchaser, because again, the new owner is going to have to honor that lease. Land use may be restricted or impacted on some properties by covenants, easements, zoning, subdivision regulations, historic preservation regulations, environmental laws, airport noise, plan, land use, another highway, right of way, federal, state, county, and local or municipal restrictions or statutes or other regulations. To ascertain how such restrictions may impact the use of specific property, information should be sought through the appropriate government agencies and/or a title search. Criminal activity: send your clients to the right place for this. Don't make statements about this kind of stuff. Just say, here's the website, here's where you can find out what the activity is on this in this neighborhood. Security systems / electronic devices: buyers advised seller may have a system on seller's property that records audio and/or video. If so, buyer's actions and/or conversations could be heard, recorded, or seen. So, yeah, I mean, there is a warning for the seller. Don't record, buyer's conversations, or they're not allowed. The fact of the matter is, you don't know what's in that house, and you as a listing agent are not going to ask your client to rip out their equipment because the house is going on the market. You can ask them to turn it off. But when you're representing the buyer, just make sure the buyer understands that these equipment could be there. Solar panels: if solar panels are installed on the property, buyers are advised to inquire about the terms under which the solar panels were installed, how to transfer the ownership or lease, and any costs associated with the transfer. Yeah, this is, I think in Maryland, we have a form, Kara, I think we have a form now in Maryland about solar panels. Let's see.
In Virginia, I had one transaction. Solar panel is inactive for ancient time. They had it.
Yeah, there is a form now for solar panels.
But non people have a really digging in harsh on that.
Yeah, well, you want to know, what the terms are, as a buyer. What are, can this be, can the lease be paid off at settlement? Sometimes there are benefits to when you're selling a property. You can pay off the lease for the remainder. I sold one, and we had just installed solar panels. It was a 20-year lease. We sold it, I think, within 3 years, and we were able to pay off the lease for $4,000.
Wow.
For that buyer. So it made sense, and it was a good selling point for us. The solar panels lease paid off, for the next 17 years.
Wow.
So this is the financial information sheet that Montgomery County and DC agents are very, familiar with. In DC and in Montgomery County, very normal for you to fill this out and submit it with your offer. So this is the affiliated business disclosure statement. This just says that we, Sampson Properties and Cardinal Title are owned by the same person. There is a 5% ownership of First Heritage Mortgage, which is our in-house lender. There are some fees here that are disclosed. It says here that no part of your working relationship with Sampson Property requires you to engage these the services of these companies in connection with your real estate transaction. So we are a one-stop shop. You can get everything done here, but you're not obligated to it. And we have to disclose that there is, benefit to us. There's, ownership of Sampson Property and Cardinal Title are by the same person. So you've got to disclose that and make sure they understand that by signing here, they're not agreeing to anything. They're just saying, okay, we saw the disclosure and here's our signature. When you send an offer for your buyer and you're going to use Cardinal Title, I would just include this with all my offers. Now, do you have to get the other side to sign this? No, you just have to make disclosure. It doesn't require their signature. We prefer that the seller's signature is on here, especially if you're using Cardinal Title. But if they refuse to, that's fine. We just want to make sure that you made that disclosure. And this is a marketing services agreement that we have with the warranty companies, Super and 210. It's a joint marketing services agreement. Again, acknowledgement of that. This isn't, any agreement to use those services. Wire fraud, again, this alert for the client. Don't wire things. You are supposed to sign this as well. What everyone should know about equal housing opportunity. This is a DC form. I'm going to go ahead and share this. Let's see. I do have one. Miguel Alvarez said, good morning, everyone.
Good morning.
By the way, Miguel is new with Sampson. He's a contractor and newer agent, and he's going to do all this here. Now let me see if I can. Let's see. Can you guys still see my? File, computer. I just want to make sure I'm giving you guys. Desktop. So the GCAAR buyer agency packet is now in the chat box if you wanna grab it there. So we went over consent for dual agency in Maryland. DC is a little different. It's just like a pamphlet. And it says what you should know about brokerage relationships. And it explains that, dual agency is allowed in DC. And everything else is pretty much the same as, the duties of the agents, the obligations of the client. Let me go ahead and put this in the chat box as well. GCAAR DC. So if you go to the chat box, you'll be able to download the agency disclosure form.
Is that Ernesto? Yes. I don't know the time.
Who's looking for me?
I don't know the time.
Hal, who's looking for me?
Oh, I lost the screen.
No, you didn't. I took it out.
Oh, okay.
Consent for dual agency representation and designated representation in the District of Columbia. Again, designated representation, what that is, what dual representation is, your client. This one is not a two-part form. This one you would actually get signed. You will get the client to sign it if either designated representation or dual representation takes place. As it is in Virginia, designated representation is when one of our agents represents the buyer and the other agent represents the seller. And then dual representation is actual dual representation where one agent represents both parties. Again, we don't endorse that at Samsung.
Ernesto, all this form is in the loop, right?
Yeah, I think so. Yes, these forms are in that loop, GCAAR DC.
And they have a different jurisdiction, Prince George's and Anne Arundel, or this different.
Yeah, you got to look at different forms, different
packages, I guess.
Different folders, yeah.
Mm-hmm.
So, consent for dual agency. Let me make sure I got this on here for you guys. So if you look at the chat box, you've got consent for dual agency there.
Is it Miguel? It used to be Long and Foster? Same name, look like. No.
Who is it?
Miguel Everest, I know the person from Long and Foster.
Okay, no, Miguel just started in real estate.
Oh, so he's too young to be.
He's a young guy.
Same name.
Right. Miguel is a pretty popular name. Alvarez is a very popular.
Yeah, Miguel as well, I think.
Yeah. Disclosure of broker's relationship. This is what you would have the unrepresented party sign. You don't need to submit this with your offers. You know, I often see agents submit this with their offer to the listing agent. You don't need to have this.
Any disclosure of who you represent, just check put the name of your company in your name, right?
Yeah, but this is for unrepresented parties.
Oh, represented parties.
Yeah. This is a disclosure of brokerage relationship in the District of Columbia. So this is given to the party that you don't represent if that party is unrepresented, not if, you know, again, don't submit this with your offers, you know, when you know that the other party is being represented by a broker. Let me add that to the chat box. A lot of forms.
I don't see any screen other than pictures.
But now?
I think I was downloading the earlier and the screen disappeared. I don't know how I can restore it.
But everybody else can see the screen, this form, Washington, D.C. disclosure confirmation of dual representation. Can everybody see? Can anyone confirm that you can see the form? CC is not seeing it. I just want to make sure that I'm not doing something.
Yes, you can see the form.
Okay.
That's why I say I lost the screen. Some reason I can see the participants, but no screen.
Got it.
whatever it is. Well, I can find the form later.
This is to be attached to the original sales contract or lease agreement whenever dual agency or designated representation occurs. So this needs to be part of your transaction, if it occurs. So let me share that too. There you go. All right.
Okay. If you go to .leave, right?
Oh, this one. Hopefully you don't have to deal with this one, right? Hopefully everything goes well. But notice the termination of brokerage relationship only. So this is how you terminate a listing agreement or a buyer agency agreement. It says the contractual obligations as defined in the buyer agency agreement shall remain in full force and effect. Again, it's referring to the detection period. So this is your notice of termination of brokerage relationship. You have this for DC and for Montgomery County. Let me put that in the chat box. And this is between client and their broker. This is not between buyer and seller. Another DC form that you want to be familiar with. The reduced recordation tax rate for some home buyers. For deeds recorded on or after October 1, 2017, the recordation tax for a first-time district home buyer purchasing or eligible property will be reduced. For houses and condominium units, the recordation tax rate is 0.725. Transfer taxes owed by the seller of 1.1 or 1.45 are unchanged. For transfers of economic interest in the housing cooperative unit, this is for a co-op. Recordation tax rate is reduced from 2.2 to 1.85. So it is a reduction. And here's what to claim the reduced recordation tax rate, applicants must, number one, complete the current version of the application ROD 11 and submit documentary evidence. Applications are subject to audit after the deed is recorded. And there's a line-by-line instruction on how to fill it out, what is required, the documents, and what the qualifying household income is effective October 1, 2020. So this is the most recent one. And the ceiling on this is $653. So if you're purchasing a $700,000 house, you're not going to be eligible for this, or the property isn't eligible for this. I'm going to put that in the chat box as well. I did make some highlights to it. Lastly, I did want to go over this. There is a separate exclusive right to represent the tenant. It is different. Maryland, I think Virginia have the one form that's either for representing tenants or representing sellers. Buyers. Is a different one for representing a tenant. Pretty much the same stuff. It applies to the tenant. And this is broker representation of tenant in Maryland and District of Columbia. It says Maryland, but it's really only applicable to Montgomery County. And I would say that if you're doing Maryland, just use the MR agency agreement. So let me go ahead and put that in the chat box.
So MR is just the uniformity of all Maryland.
MR is for Maryland, right? Mm. Like across.
Yeah.
Yeah. Where did I find this? It's called the exclusive right. For some reason, I can't. Escalation clause. Sorry about that. I might have to. I'll owe you guys that one. Any questions about buyer agency, DC or Maryland that we can address for you? Does anybody have any questions that we can go over?
Ernesto, this is Joanne Smith. In purchasing land, when you're doing an agreement or a contract with somebody for purchasing land, is there anything different about land purchase?
Is one different? I'm gonna have to ask my brokers here. Kara, are you aware of, I think it's the same one, you can use the same one, but are you aware of any agreements for a buyer looking for land?
Not with regards to the brokerage relationships and the right to the contracts to represent. It's right. The differences will be in the forms you use for the contracts.
Yep.
Okay, so there is a different form. It's not just a regular GCAAR agency agreement form.
No, there's no difference with regards to the representation contracts and the agency contract or the agency relationships. So these are the same forms. It's if you're the unimproved land contract of sale and the unimproved land addendum to the contract of sale. So with regards between the broker and the client, there is not a difference.
Okay.
Yep.
Okay. Unimproved land. Okay.
Yeah. So and I know, so the for example, in the Maryland Realtors exclusive right to represent the buyer, they have that box in the very first page that says that where you are supposed to describe what the buyer is looking for. So a description of what they're looking for, if it's unimproved land or something like that, would go there.
Okay.
Howland, maybe do we have any other forms in any other jurisdiction that you may be aware of? I'm not aware of any.
No, Ernesto, there's no different. Kara covered it all. That's all. That's the only thing that we need. Okay. Just to make sure that when you're filling that form out, that you have all your inspection dates in there in terms of if we're not in the time of year where we can do, what are they called, Ernesto?
Like your feasibility studies.
Yeah, right.
Yeah.
The feasibility study, and make sure that stuff is in the contract, because if you don't have it in there, you're saying technically I'm buying the land without those studies being included.
Yeah, and those will all be found. The unimproved land contract addenda or contract of sale, and those addenda are pretty good at kind of checking off everything that the buyer wants to have included.
They're very, very good, because so many places, and especially in this area, you have to build an above ground septic system, and most people don't want that. So you have to make sure the land that you're selling can hold the septic system and all that kind of thing that you want to do with it. You have to make sure that's there. It's able to do that. If you write that contract without that stuff in it, the seller of the house is gonna, or the land is gonna figure that you're just buying the land as is. And if you're trying to build something on, you want to make sure it's a buildable lot. That's the most important thing. And sometimes that can take as much as 5 or 6 months to really find, especially if you're in the wrong time of year. That can take a long time. If you're buying this land in July and they have not had the, it's not the feasibility. What is the other study where PERC? Haven't had the PERC that haven't never, it's never PERC before. Right. You do PERC tests between, I think is it January and April, something like that? Something like that, somewhere in that time frame. So if it's if it's September and the land has never perked before, you have to wait until that season comes. So yeah, so you can be tied up a long time with that. It's not just as simple as writing like how you would write on a house. It's not that simple.
Mr. Wilson, may I ask you, what is PERC? What does that mean?
To make sure the land has water flowing on it, that it can actually handle the water system and the septic system. Because otherwise you would then have to build an above ground septic system, and most people don't want that great big box sitting on top of their land with food and all that kind of stuff running into it. And if you don't have water on the land, you can't use it if you have no water on the land. So making sure that it PERC is just making sure there's water all over the land, that they can, when they drill down the land to bring your water in, that they can actually bring water in.
And that is one of the questions that, people that are looking for land have, has this been PERC, or has it PERC? How many bedrooms has it PERC for? That kind of stuff.
Oh, okay.
Whether they can be actually buildable or not.
Right.
How fast a certain amount of water you put in dig the hole, it penetrates ground. Right. I don't know all the details. It is PERC means if you happen to have septic system, will they accommodate?
Right. And the other thing with that is that the size of the house matters as well. So that's one of the other things they'll ask. Is it a 2,000 square foot home or a 5,000 square foot home? Are you gonna have 4 bathrooms or 5 bathrooms? Because everything makes a difference when you're looking for water to flow on a property.
Is that a Maryland is the difference of square footage? Virginia is a number of bedroom per case.
This number of bedroom is actually, well, I just went through this myself personally, so I do know that the bathrooms matter. If you have 4 bathrooms versus 5, there's a different test that has to be done. Yep. And a different fee as well.
Oh, the Virginia is always go after for number of bedrooms.
I literally just went through this myself personally. So,
Mr. Wilson, can I have your email address?
Yes, I'll put it in the chat.
Okay, please. Thank you.
Mm-hmm.